Ayes have it. Call on Government Order of the Day number 5.
Crimes Amendment Bill number 2, committee stage.
I declare the House in committee for consideration of the Crimes Amendment Bill number 2. Mr. Chairman.
Speaker. Members, the House and Committee on the Crimes Amendment Bill number 2. The question is that Part 1 stand part.
Mr. Speaker.
Honourable Simon Power.
Part 1 of this bill contains the substance of the policy and is the part to which the Parliament needs to address its special attention. This government came into office with the specific intention of developing an appropriate response to violence against children. We are well aware of the incidents which have resulted in horrific deaths and injuries of young and vulnerable children. Far too often, the perpetrators or the parents and caregivers of these children are able to evade their responsibilities. An effective response is required. Part 1 of the Crimes Amendment Bill number 2 provides a significant step towards making New Zealand a safer place for our children and vulnerable adults by holding those responsible for the care and welfare of the vulnerable, as well as the perpetrators, to account. This bill represents a small but significant step in responding to incidents of abuse of the most vulnerable in New Zealand society. Other measures, such as those outlined in the Green Paper for vulnerable children, as well as a greater willingness by communities to prevent these incidents, are required if we are to seriously address the scourge of child abuse. Mr. Chairman, I apologise. The bill itself spends a small amount of time looking specifically at the ill treatment or neglect of a child or vulnerable adult. In particular, the bill deals at clause 151 with everyone who has actual care or charge of a person who is a vulnerable adult and who is unable to provide himself or herself with the necessities under a legal duty. Deals at 152 with the duty of a parent or guardian to provide necessaries and protection from injury. And in particular at clause 195, new section 195, ill treatment or neglect of a child or vulnerable adult. Everyone is liable to imprisonment for a term not exceeding 10 years, where they intentionally engage in conduct that or omits to discharge or perform any legal duty, the omission of which and the significance of the inclusion of matters which are omissions will be no doubt the topic of some discussion following the tabling of the amendment by the ACT Party in respect of its concerns as to how those offences should be treated. And that is where no doubt I'll be looking to take another call to describe the subtle difference between the omission and commission and duty-bound statute and offences as opposed to those which may be involved in the actual commission of a serious or violence offence which would attract strike provisions under the sentencing legislation. What section 195 does is to make sure that those who have oversight, being a person described in subsection 2, that legal duty is likely to cause suffering, injury, adverse effects to health or any mental disorder to a child or vulnerable adult, known as the victim in this part of the legislation, if the conduct engaged in or the omission to perform the legal duty is a departure from the standard of care to be expected from that particular reasonable person. 195A goes on to specifically deal with this issue of a group of people close to a household or in a household who would be basically considered to be part of that, Mr. Chairman.
Honourable Simon Power.
To be part of that household who knows that the victim is at risk of death, grievous bodily harm or sexual assault as the result of an unlawful act or an omission by another person to discharge a legal duty and fails to take reasonable steps to protect the victim from that risk. The clause goes on to say that those persons are a member of the same household as the victim or a person who is a staff member of any hospital, institution or residence where the victim resides. For the purposes of clarification, the clause goes on to say at clause 4A, a person is to be regarded as part of that household even if she or he, other way around actually, he or she does not live in that household. But if that person is so closely connected with that household that it is reasonable in the circumstances to regard him or her as a member of the household. In particular, where the victim lives in different households at different times, the same household in this legislation for the purposes of Clause 4A refers to the household in which the victim was living at the time of the act or omission giving rise to the risk of death, grievous bodily harm or sexual assault. In other words, it is no longer enough to simply turn one's mind, to turn one's attention, to turn one's face away from the harm or the risk of harm that is occurring in that household and say, nothing to do with me. I saw nothing occur there, and because I have no legal duty as a parent or the equivalent statutory substitution, I attract no legal liability. This legislation says not good enough. Not good enough. If you were a member of that household for the purposes of that legislation and you know that the victim is at risk, the person who has that knowledge now finds themselves, when the passage of this legislation eventually concludes, bound by a duty to take some responsibility for what is occurring in that household. No longer will the cone of silence be able to descend over a family group who refuses to tell the police what occurred in that household when they can reasonably be expected to have known. This is a step that I hope the Parliament endorses, as it did at the second reading by quite a substantial majority, to confirm that this Parliament is prepared to take the steps necessary to protect those children and vulnerable members of society who find themselves in those households and in a legal sense are unable to reach out to those who should know better and intervene in activity that is putting those children or vulnerable parties at risk. And this is the first step, Mr. Chairman, in this process, but part of a wider piece of work the government has been doing to try to protect children and vulnerable parties. I look forward to hearing the debate in the committee stages on this issue, and at a later time during this part of the discussion, and happy to address the matters contained in the submission, or amendment rather, that has been tabled by the ACT Party.
Dr. Rajan Prasad.